Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. This morning, we have what is called an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in County Court at Law number 2 is a misdemeanor case. Criminal cases are divided into felonies and misdemeanors. The felony cases are more commonly referred to as your more serious type of criminal offenses. Your misdemeanor cases are normally referred to as petty offenses. Does not mean that they're not serious. It just means that they are not as serious. For example, if you have a felony case, your felony case could be either capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. If you're charged with a state jail felony, the range of punishment is anywhere from 6 months to 2 years in the state jail, fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is anywhere from 2 to 20 years, and the fine is from 0 to up to $10,000. If you have a first-degree felony, the range of punishment is from 5 to 99 years to life, and a fine up to $10,000. And if you're convicted of a capital murder case, the range of punishment is either life or death. Now, if you have a misdemeanor case, and you have a misdemeanor case, your range of punishments, you have ranges of punishment as well. For a misdemeanor, you have a class A misdemeanor, class B misdemeanor, or a class C misdemeanor. If you have a class C misdemeanor, your range of punishment is a fine only. Normally the fine is up to $500, but it's a fine only. If you have if you have a class B misdemeanor, the range of punishment is anywhere from 0 days to 180 days, which is 6 months in the county jail, a fine from $0 to $2,000 or anywhere in between. If you're convicted of a class A misdemeanor, the range of punishment is anywhere from 0 days to 365 days, which is a year in the county jail, a fine from $0 to $4,000 or anywhere in between. So you can see the difference in the range of punishment from the felonies and the misdemeanors. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is you have a right to have an attorney. Now, the clipboard that you have has that information on it, and I'll go over it with you. The first document states, or is titled, Judge's Explanation of Rights to Defendants Without an Attorney. As a defendant in a criminal case, you have 3 options. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number 3, you may represent yourself. Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. At the bottom of that document, it states, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you have already been appointed an attorney on this case, then you will put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will write today's date on the line that is titled date. And today's date is March 22nd of 2022. Now, for those of you who will be waiving your right to have an attorney, and waiving your right to have an attorney is that you're giving up your right to have an attorney and you'll be representing yourself, you will read and sign the second document on that clipboard. That document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 22nd day of March of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right, and waiving that right is giving up that right, and request the court to proceed with my case without an attorney being appointed for me. I hereby waive or give up my right to counsel, and counsel means attorney. If that's your choice, then you will sign on the line that states defendant, and you will place today's date, March 22nd, 2022, on the line that is titled date. Now, as a defendant in a criminal case, you have other rights, or you have more rights. And you also have a right to have a trial by jury. That area over there in the courtroom is called the jury box. And what that signifies is that's the area where jurors will sit. Now, there'll be 6 individuals selected who lives in Jefferson County, and they will listen to the evidence in your case. And at the end of the evidence, they will decide whether or not you are guilty or innocent of their charge. Now, you have a right to waive, which means you have a right to give up your right to have a trial by jury as well. And by waiving your right to have a trial by jury or giving up your right to have a trial by jury, then what that basically means is you will not be having a trial by jury. And by you not having, and because you will not be having a trial by jury, then your case will come before the court or before the judge in one of three ways. It can come before the court by way of a trial. And that trial will be a bench trial. We call it a bench trial because you will not have a jury. The judge will be listening to the evidence, and the judge will decide whether or not you are guilty or innocent. And the judge, if the judge finds you guilty, the judge will also assess your punishment. So that's one way. Another way your case can come before the court is by way of a plea. You can have what is called an agreed plea bargain or an unagreed plea bargain. The agreed plea bargain basically means that you and your attorney have reached an agreement with the district attorney's office to settle your case. Y'all have reached an agreement. Now, that agreement to settle your case will come before the court or before the judge, and the judge does not have to follow your agreement. Now, if the judge does not follow the agreement that you and the district attorney has made to settle your case, you can take your plea back. In essence, you can withdraw it. You can say, well, judge, since you're not following the plea, I withdraw my plea. I'm not pleading guilty. I'm not pleading no contest. You have a right to do that. Now, if the judge does follow the plea bargain, and if you decide that you would like to appeal your case, you have to get permission from the court or from the judge to appeal your case. And one of the appeal is you want to hire a court to look at your case to see whether or not you've been wrongfully convicted or whether or not the court has committed an error by convicting you. Now, the other way that the third way that your case can come before the court is by way of an unagreed plea bargain. What an unagreed plea bargain is, it means that you and your attorney or you and the state have not been able to reach an agreement to settle your case. However, you still would like to plead your case. And when I use the word plea, plea means you can enter a plea of guilty or no contest. If you enter a plea of guilty, it's telling the court you committed the offense that you've been charged with. If you enter a plea of no contest, you're telling the court that you did not commit the offense that you are not fighting the offense that you have been charged with. That's what no contest means. You're not contesting the charges, you're not fighting the charges. Now, if you still want your case, as I said earlier, to come before the judge by way of a unagreed plea bargain, that means that you and the state have not agreed on what the punishment is, but you want the judge to decide. And so the judge will decide what the punishment in your case is, okay? So your case can come before the judge. If you waive your right to have a trial, it can come before the judge by way of a bench trial. It could come before the judge by way of an agreed plea bargain, or it could come before the judge by way of an unagreed plea bargain. Now, you also have a right to have witnesses to come to court and testify in your case. That chair right there, we call that the witness stand. And what witnesses will testify from that chair. If you're representing yourself, you can ask them questions. If you have a lawyer, your lawyer can ask them questions. And we call the questioning either direct examination or cross-examination. Now, you have a right to waive or give up your right to have witnesses to come to court. In essence, you have a right not to have any witnesses, you have a right not to call any witnesses on your behalf. Now, that does not mean that the state, the district attorney's office, will not be calling witnesses in their case. It just means that you will not be calling witnesses in your case. You also have a right to have discovery. Discovery means you have a right to see the evidence that the state or the district attorney's office has against you. They filed a charge against you, you have a right to see the evidence. We call that discovery. Now, if you want to have discovery, the state can allow you to have access to the discovery. In essence, you'll be allowed to see the videotapes or the witness statements, police reports, or objects. If they had any objects or whatever they had, whatever evidence they have, you have a right to see it. Now, you also have a right to waive or give up your right as well, which means you have a right not to see it if you don't want to see it. Okay. Now, you also have a right, and I'll get back to the witness thing. You have a right against self-incrimination. What that means is you have a right not to testify in your own case. In essence, nobody can force you to testify in your case. If you decide you didn't want to testify, you have a Fifth Amendment right against self-incrimination not to testify. I know if you watch television, you've probably seen people say, I take the fifth. So that means that, you know, I don't want to testify. And you have a Fifth Amendment right in the United States Constitution not to testify if you choose to, and nobody can force you to testify in your own case. Now, everyone here is here because you're out on bond. You're either out on a surety bond, meaning that you have to pay a bondsman, or you're out on a cash bond, meaning you paid it all up in cash, or you're out on a PR bond, which means you was released under your own or your personal recognizance. That's what PR bond means. Now, every day that you spent in jail on your case, you can get credit on that day, and that goes toward, or for those days, that goes towards your punishment. For example, let's say you was booked in jail at 11 o'clock at night, 11 o'clock midnight, and then you got out 2 hours later, 1 o'clock the next, 1 o'clock in the morning. That's 2 days. They don't go by 24 hours, they go by, it's a different day, so it's 2 days, okay? So if you stayed in jail, let's say you and the state has reached an offer, let's say you stayed in jail 5 days, and you and the state have reached a plea bargain agreement, and the plea bargain agreement is that your punishment will be 5 days in jail. What that means is you would not have to serve any more time in jail, because the 5 days you served in jail is going to be credited towards your sentence. So therefore, you'll be given what is called credit for time served. All right. Now, if you spent 3 days in jail and they offer you 5, that means you have to do 2 days. Now, let's say the state, though, now every day that you spent in jail also is credited as $100 per day that can go towards your fine and court costs. So let's say the state is offering you fine and court costs of $500 and you spend 5 days in jail. What that means is you don't have to pay anything, because the 5 days that you spent in jail has already paid it off. Therefore, your fine and court costs will be taxed and retired. That tax and retired means that you've already paid it. You don't have to pay it off. You don't have to pay it again. All right. Now, if they offer fine of $700, fine and court costs of $700, you did 5, that means you have to pay $200. But let's say you can't pay the $200 on the day that you're in court. Then the court can put you on a payment plan. You can pay it off in installments, all right, until you pay it off. Or let's say because of your financial situation, you do not have any income and you cannot pay it off. Then the court can convert your fine and court costs to community service. Now you get, but every hour of community service will be credited at $12.50 that will go toward your fine and court costs. So if you work 8 hours one day, that's $100 that will go toward your fine and your court costs, okay? Now, Jefferson County has a program that is called pretrial diversion. Pretrial diversion means for anybody who is their first time getting in trouble, and your offense, the offense that you have been alleged to have committed is not a unlawful carrying a weapon case or a resisting arrest, if it's not one of those two cases, you may be able to get into the program. And you have to have a lawyer or have a lawyer to assist you to get into the program. If you get into the program, this is what will happen. Your case will be dismissed. Once you complete the program, you can get an expunged from your record. Expunged means it could be erased, deleted, or wiped off from your criminal record. Okay? So again, in order to get into the program, it has to be your first offense. It cannot be an offense involving unlawful carrying a weapon or resisting arrest, and you have to have an attorney to help you with the application to get into the program. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has another program that is called Veterans Court. It's for veterans. It's the same thing like pretrial diversion. You get into the program, you complete the program, the case is dismissed, you get it expunged from your record. And I don't know if they have a requirement as to what the different offenses are or that you can get in, but if you're a veteran, you can get into the program. So the main criteria is you have to be a veteran, okay? Now, Jefferson County, well, this court, County Court at Law number 2, has a program that is called CSI. And CSI program stands for Community Safety Initiative. It's a program that I started within the first 100 days of taking office. And that program was started in March of 2017. And that program is designed to make Jefferson County a safer place for all of us to work, go to school, raise our families, go to church. And the way the program works is we have partnerships with local agencies. We have a partnership with Spindletop Center. Spindletop is our local mental health agency in this region. With Spindletop, and we have individuals in court, we have counselors, we have mental health deputies that's here. They can do private interviews. Spindletop can do a assessment, develop a treatment plan, either outpatient or inpatient, to meet your mental health needs. Now, your mental health needs, I'm not talking about that you have to be insane or you have to be incompetent. You can have anxiety, depression, you could be bipolar, schizophrenic, post-traumatic stress, or whatever other type of mental health issues that you may have. They can help address those issues. Spindletop also has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And with that program, individuals who are 21 years old or younger, if they have issues with drugs or alcohol, then they can address those needs by a screening, an assessment, and develop a treatment plan, either outpatient or inpatient. Now, for individuals who are 21 or older, there's the OZAR. We call it Outreach, Screening, Assessment, and Referrals. And what they would do, they can do a screening, they can do an assessment, and then from that, they can develop a treatment plan and refer you to either outpatient or inpatient treatment. If you are unemployed, do not have a job, or looking for a better job, we have a partnership with the Golden Triangle Empowerment Center. Golden Triangle Empowerment Center has a program, they have a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. Basically, it is a job training program and a job placement program in either the shipping industry, the hotel industry, or the chemical industry. Once you are trained in one of those areas, they will assist you at getting a job in the area that you're trained in. Now, for those of you who have not, if there's anybody here who have not graduated from high school, CICE has a program, it's a GED program, and they could assist you with getting your GED. Now, all of the programs that I just mentioned to you are free. Does not cost you anything. Only thing you have to do is have a desire to be in one of the programs. The other benefit of the programs is they all could be used as community service. And so, for example, let's say, I tell people this all the time, you could kill 3 birds with 1 stone. And the way what I mean by that is, let's say you was ordered to pay a fine and court costs, and but you do not have the income to pay it. And so the next thing, they put you on, they converted to community, we converted to community service. And then let's say you're in one of the programs, let's say you're in the job training program, or the GED program, or the Spindletop program, or a drug and alcohol treatment program. Either one of those programs, that's the third thing. While you're in one of those programs, you're going to be having 12, every hour that you're in the program, 1 hour is going toward community service, and $12.50 is going toward your fine and court costs. So you're doing one thing in the program, but you're getting credit for community service, and you're paying your fine and court costs while you're being trained on a job, or while you're getting alcohol or drug treatment, or while you are, being treated for your mental health needs, or while you're in the GED class. So all of those programs that I just spoke of can be used as a community service, and it can go towards your fine and court costs. So you're doing one thing, but you're getting credit for 3 things. And I tell people this all the time, when you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference in Jefferson County by making Jefferson County a safer place. In this court, we do not just give time, we take our time. In essence, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, then they have too much to lose, and they would not commit crimes, and therefore we will make Jefferson County a safer place for all of us to live, work, and go to school. So if you're interested in one of those programs, just let us know. And we have the materials here to direct you to the right place to address your needs. Now, as I stated earlier, we have people here from Spindletop. We have Deputy Hinton. He's a mental health officer. He's going to come forward, and he's going to tell you a little bit about what they can offer at Spindletop. At this time, Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I have a mental health district license by the state of Texas. I'm here with my partner, Chris. She's a qualified mental health professional in Spindletop. The reason we are here is because the judge has graciously allowed us in this courtroom because he does care about every single person that comes before his bench. And what the judge has found, more so than not, that people who appear here with legal issues commonly have either substance use disorders or mental health issues. If this is you, there's hope. We can provide you resources, we can advocate for you, we can work with you to get you out of that cycle of arrest, should this be your first time, or maybe it's your 10th time. There are services out there that we can help you with, and that's what we want to do here today. And maybe this doesn't apply to you, maybe it applies to a family member who would like to get this information to you so you can take it back to your family member as well, and we'll be glad to work with them. At the very least, I want to get this in your hands. It's our flyer. It talks about a little bit who we are and what we do here in the court. But on the front side is a 1-800 crisis number. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. We want to get this to y'all. We also have a little demographic sheet here. we'd like y'all to look at and fill it out. We'll pass it out to you here shortly. And, it has a block on there that if you wish to talk to us outside the court later on, I understand your privacy. If you want to talk here, we can speak here in private. All your information is, obviously HIPAA regulated. We cannot speak of it outside of your permission, but it's up to you. It's just going to take a bold act on your part because if this does apply to you, you're going to have to share that need with Chris or I so that we can help you and provide those resources and direction for you to get you where I think that you really want to be. Does anyone have any questions? Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Hinton. Now, ladies and gentlemen, the paperwork that we handed out to you, we're going to have someone from our court staff. If you need any assistance, they'll be able to help you with that. And so this is going to take a little time. And so at this time, we'll be in recess to give the staff an opportunity to pick up the paperwork from you. And then once the paperwork is picked up, then we're going to call you up one at a time before the bench. So at this time, the court will be in recess